Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss an important point. That is, if any ganja or any narcotic drug or psychotropic substance was found in a mutt, can the priest be held exclusively liable? This is an important topic. Please remember, Bombay High Court, single judge, Justice Sandeep Shinde, while disposing the case of Shantaram.B alias Babu Maharaj versus State of Maharashtra in bail appeal number 1025 by 2022 on 9th November 2022, held that temple from which the ganja seized is not in the exclusive possession of the priest, so therefore he cannot be held liable for the possession of the ganja granted bail. This is an important thing. Now please remember, Justice Sandeep Shinde, while dealing with the petition, allowed bail after prima facie being satisfied that the temple is not in his mutt. Actually, it is a mutt. Mutt is not exclusively in his possession. Now we will go to the details of the case. The prosecution case, they say that the excise people on reliable tip-off or reliable information, they conducted a raid on the so-called Babu Maharaj Trust and found, please remember, the mutt was in possession of the cultivation of the ganja. So where 10 cases of ganja was recovered. In addition, the cannabis sativa or ganja plants, they were cultivated, they were uprooted and they were destroyed, and they destroyed weighing about 31.445 cases. This is one part, ganja. And antlers and skin of the deer were found. So to Wildlife Act also. Now the excise police, they booked cases under sections, of course, 8 clause 2 read with 20 of the NDPS Act, and also section 2 clause 16, 9, 39, 48A, 49O, 51 and 52 of the Wildlife Protection Act. So this case is relating to Shirur PS, SHIRR, PS of Pune city. So the reliable information was obtained by the excise police. They went there and they found the cultivation of ganja, the commercial quantity, that is 10 kg of ganja, and also they destroyed the same. Definitely they filed the case under the above sections of law besides the Wildlife Protection Act, because the deer were also found, skin of the deer was also found, and they filed the charge sheet also. Now when the matter was called for bail petition, then the Honorable High Court has to see the entire file, and the file clearly discloses that there is no iota of evidence, IOTA, there is no iota of evidence to link the priest with the mutt. It is not in his exclusive possession. That too, it is a public place. The devotees, they are visiting the place, so some of them might drop it also. Is it not? It is not in the exclusive possession of the priest, no doubt. And the recovery of 10 kgs of ganja, it's not a commercial quantity. So therefore, the rigorous provisions of Section 37 of NDPS Act will not apply. So here the main point we have to consider is whether the priest is in exclusive possession of the temple, of the mutt. If he is exclusively in charge, he has to bear the burden and by the name of the vicarious liability. Here he is after all a priest. Daily he comes to the mutt, he performs puja and he goes away. How can he be held responsible? So please remember, so this is a case where the judges show their wisdom. So ultimately, since it is not in the exclusive possession of the priest, and since there is no iota evidence of linking the priest with the so-called NDPS offense, he was released on bail, of course, with certain conditions. The conditions are like, okay, he has to be released on bail after furnishing surety of 30,000 for his personal amount, along with 2 sureties to the satisfaction of the SHO or things like that. Second is, he has to attend before the court once in a month, particularly on the second Monday of every month. Then he should furnish his permanent address to the police officers so that they can check his movements, whether he is present, whether he is absent, whether he is going anywhere, things like that. So, please remember, the court has got the liberal attitude. Otherwise, this Babu Maharaj or Shantaram.B would not have gotten bail. So, please remember, very good case law. So, please read it and enrich your legal knowledge. With this, I am concluding here. Thank you very much.